All set.
You know, I only charge like 8% interest
What is that that you?
per month.
We're recording right now.
All right, I'd like to call the meeting of the Unified Land Development Code Review Committee to order. Today is Thursday, August 15th, 2013. It is 5:42. Sue, would you like to do roll call?
Chair Standish,
Here.
Vice Chair Davis,
Here.
Committee Member Heisler,
Here.
Committee Member Ryan,
Here.
and Committee Member Warren.
Here.
Okay. Anyone would like to make a motion to approve the agenda? Make a motion to approve the agenda.
I'll second that.
Okay. All in favor? All right, 5-0, agenda is approved. Okay. Let's move on to the minutes, and I would just like to remind the committee and myself that this is an advisory committee, and the P and Z and Town Council have the final input, so we are advising them, we're not making law tonight. Okay, go on with the minutes. Do you want to approve the minutes? Do you have a motion to approve the minutes?
I'll make a motion to approve the minutes.
Second? A second. Okay, all in favor?
Aye.
Okay, 5-0. Discussion of the minutes?
Do we have a discussion of the minutes if we all approve them?
Usually you talk,
Do you want to?
I'm just saying, you can approve them, have a short discussion afterwards. Did I miss stuff there?
You can do the motion,
And then,
and then discussion, and then vote.
oh,
So maybe,
okay.
maybe you voted too fast, but
Okay.
that's only if somebody has a comment.
Well, usually someone would say something, or they're very quick on the minutes. John's usually hitting.
The only thing I was gonna say was that Mark agreed to give us an update on what's transpired with the FEMA activities as part of the minutes, and I didn't know if that was a specific agenda item or whether that was.
Well, that's in here tonight.
It's part of the.
Yeah.
Okay.
Okay, so let's go on then. Minutes are approved. Okay. So we're to item 3, regular agenda. Item A, old business.
Madam Chair, before I get into item 1, because my preparatory comments kind of relate to some things I'm going to be talking about in that, I just wanted to make the committee aware that at our August 20th Town Council meeting, I'm going to remind the Town Council, try to give them some time to provide any additional items that they may want us to take before you, because as you know, this board sunsets at the end of the year. So, I want them to start thinking about it, maybe so that in maybe the second meeting in September or first meeting in October, we can, at that level, either have a discussion and or have them give me additional items, concerns, issues they have that we can try to bang out our last 3 months as we're meeting here. And so, based on that comment, kind of gets into what I wanted to talk about relative to the FEMA issue. Since we met at our last meeting, Palm Beach County had a meeting with FEMA officials on July 31st. And at that point, I attended along with our general engineering consultants who have come on board, have reviewed the maps, find a lot of flaws and issues, and have prepared a response that the town has submitted to FEMA, identifying some concerns that we have. And I will provide a copy to you on that at our next meeting. I don't have it with me tonight. However, the July 31st meeting was very illustrative because it was a technical meeting. So it was more for the engineers and the consultants that all the cities had, but yet you had all other city folks, elected officials, city managers, etc. FEMA kept indicating, what had happened was Palm Beach County did a nice job coordinating with the cities, and there were, and if anybody's at the council meeting, I kind of reported on this, so if you're hearing it twice, I'm sorry. They set up a lot of experts to explain to FEMA, and then FEMA's consultants, what was wrong with the maps, basically. You know, there were real good people. Dick Tomasello was there, of course. Ken Todd is leading the charge from Palm Beach County. A number of cities' engineers spoke. FEMA keeps coming back to the point that they are not supposed to basically look at any of this input until the 90-day appeal process starts. However, they have been looking at it, so therefore, we should be, thankful kind of thing. You saw there was an article in the paper where our county officials were able to get at least 4 members of the county's legislative delegation to send FEMA a letter. I think that was very helpful, indicating some of the concerns. And, we were set to have community participation meetings start on the 9th of September, and then that's when the 90-day process would kick in. Well, we received an email, actually came on August 8th, and that's why I'm saying I think the legislative delegation letter really helped, because they indicated that they appreciated the opportunity to meet with us on the 31st in West Palm Beach. And they indicated that they are now willing to revise the preliminary maps based upon better technical data, and that we have till November 30th to go ahead and provide them with revisions. And they don't expect to, they will probably be issuing the new preliminary maps in the spring of 2014. And then, of course, they will also, on the 9th, they're going to, again, reschedule the public meetings, and then the 90-day appeal process will start. So we basically bought ourselves a lot of time from the Palm Beach County effort to work with them and to get with AECom, who's their consultants, and to try to make some headway. I mean, one of the things that the county folks had indicated, the FEMA folks had indicated to us was that apparently there are like map amendments and things that changes to the floodplain mapping that cities, developers, everybody should have been sending to them all along. I guess they call it a map amendment, basically that apparently they were trying to indicate that a lot of that was not happening. I don't know if that was a valid criticism or not, but I guess everybody's not being more vigilant and make sure they do that when there's a change in any subdivision or whatever that's going to impact flood mapping. So we're at the point now where this is a really good thing. We're going to have a lot more time to try to write these maps and make sure that they don't have a deleterious effect on the town. Having said that, the reason why I'm backing my comments in to what I started off with and talking to council, since this group is sunsetting, I think the big decision before you do mapping is obviously this effort is going to go well past your intended life as a committee. So I think rather than getting tied up or in the minutia of what this model code says and what that code says or what Palm Beach County says, I think the big issue, the big recommendation that you guys are going to have to make to town council for the future is going to be which way we go. Now, if you still think you need to get into that, all that minutia in order to make that determination, that's certainly something you all can deliberate and talk about. But I really think the best recommendation that you could make to the town council is which way we should proceed after we get through this process with FEMA. Maybe that's impossible to do because we don't know how it's going to shake out, but it's rapidly changing, and so we're not going to know for a while. So I think the best input you can get is in that regard. And with that, I'll answer any questions you may have.
As part of the minutes, didn't Jim indicate that he had talked to the county and they really are not too interested in us piggybacking on them?
That's what the county did tell me, but I'm not sure that they interpreted my question properly. I don't think that we should give up on that issue because in my mind, the floodplain ordinance is best administered by whoever's going to be handing out the building permits, and that's not us. So
Palm Beach County.
yeah, Palm Beach County does that, and I think that we ought to continue to press to either be included under their ordinance or adopt their ordinance by reference and enter into some kind of interlocal agreement when they actually administer the ordinance in the town for us. So, yes, I did get that, I did get that answer initially, but I don't think we should give up.
Mark, have you
Let
got-
me comment on that too, because I have some additional information.
And then
Wonderful.
Howard after your.
In that
I was
regard.
wondering if you got any feel from the other
Well-
towns about doing the same thing.
No, because they're not, most of them are not in the same boat as we are. I mean, maybe a few of the smaller cities, and I haven't had a chance to check with them. But relative to the point about the county, that is a big issue for the town. And I've talked to Attorney Cirillo about it. He's gonna look into it. The issue basically is that we have an interlocal agreement with the county. And the county basically does all our in-progress inspections, if you will. They review them, they keep the permit fees. What we do is we review the plans up front to make sure that there are no inconsistencies or problems with zoning and land use.
And then it
We
goes to
stamp
their.
it, then it goes to the county, and we really never see it unless a problem comes up. They do all the inspections and et cetera. In that interlocal agreement, however, it states that they don't provide any other building official services.
Wait a minute, Mark, you're saying plan review is done by the town, and once you stamp those plans, there's no plan review by the
No,
county?
plan review is done by the town for zoning and land use. They still-
Zoning
they
and
still-
land
they-
use.
They do everything else, the building review,
Okay.
plan review, the inspections, et cetera, et cetera. So, because our agreement, our interlocal agreement with the county seems to have a hole in it, it presents not only a problem in something like this, and the reads we're getting from the county, but there are other issues out there, and I'll give you a couple. For example, we had an issue with Sunsport Gardens, and some things that were going on up there, and that the task force led by the sheriff's office has asked us to follow up on the code enforcement violations. Well, we really didn't have a citizen complaint. This is actually coming from the task force. But our code enforcement vendor is a little concerned because although they have building official personnel, she got to read almost like Jim got, that, well, you can only have one building official and that's us. And I said, that's crazy, that ties my hands. They're telling me in the agreement, they're not going to do that, but yet I can't go out and do anything about an issue that comes up that needs a building official review, whether a building is unsafe or there's a matter. That can't be right. We have to be able to have a discussion. I really got concerned when Jim was kind of given that same kind of information, but it almost sounds like I may have to go visit the county commissioner and talk to him or somebody at the county if those are the kind of interpretations coming out of them. Because I think that's a very strict and rigid interpretation. The Florida Building Code does require you to have one building official, but I can tell you, I've run organizations where I've had up to a half dozen people certified as building officials. I think what that means is one person has to be the building official in an organization. You can't have different people making determinations. I don't think the county can tie our hands if we wanted to. If they're not going to do it, then we should be able to contract with somebody else for both the in-progress inspections and the building official services. We had a fire to a residence, and we're getting some complaints from the person. They want us to get involved. Again, we don't have a building official, so
Wait a minute, doesn't the county have in progress, and then the building official is over them?
the
So,
building official is over them.
Right.
Our interlocal agreement basically states they're not going to do that for us.
so we
limits
have to
the-
have a building official.
We have to have a building official of some kind. And I'll give you a good example, because I've done these agreements in other cities. We're in hurricane season. God forbid should we get whacked by a serious hurricane, I mean a serious one where it's Hurricane Oh-No, and it comes, and it hits Loxahatchee Groves, and we have devastation and everything. We need somebody who's gonna be able to go out through the town and make these determinations if structures are unsafe, inhabitable, those kinds of issues. Well, if the county's gonna tell us they can't do that for us, then I gotta have somebody who can do that.
But the question, but let me make an assumption.
I'm relaying it to concerns by Member Ryan.
Right, and I understand that I just want to make sure I understand what you're talking about having a building official. You would have someone that is trained in this, like Two and Taylor or something.
June Taylor has folks on board that are building officials, but
Right.
she's concerned because of this read from the county that we can't do that. We're your building official. Well, if you're my building official, then I shouldn't have an interlocal agreement which says you're only gonna do this because you're getting building permit fees, but you're not gonna do that.
Right.
Now, maybe what they're doing is looking for another fee. And if that's the case, fine, let's sit down and talk about it. But I get a little concerned when and I'm hearing this from my vendors, I'm hearing it from Jim, I'm hearing it from Beverly, and I'm saying at some point I may have to have a little talk with, the county and find out what's going on. Because that just isn't right. And I mean, there are other potential vendor sources where we don't have to necessarily go with the county if that's the case. I mean, it is efficient, and it makes sense the way we're operating today. But town also has to have the services somewhere for building. So,
Howard?
Yeah, I have a mental disconnect with what's going on, and hopefully you can straighten me out. I really don't quite understand what any of this has to do with us and what we're supposed to be doing in the time we have left. I see it being a grave issue for the town, no ifs, ands, or buts. But as a ULDC review committee that's trying to fix the verbiage and what have you of what's broken with the current ULDC, what does any of this have to do with us in the little bit of time that we have left to fix the things we need to fix that have already been identified? This whole FEMA thing, in my mind, it's not worth me thinking 1 minute about it until it all comes out in the wash and you professionals do what you need to do to protect us as much as you can, and then we can make intelligent decisions.
well, the reason why it's before you, even before the firm maps came out, is because council wanted you to give them input on the floodplain ordinance issue. And, as I just suggested, probably the best you're gonna be able to do at this point in time, because that issue is definitely gonna outlive, or at least outlast, your composition as a board, your timeframe, is to recommend the council a potential action in terms of which way they should proceed. Whether it's 85% of the town in the floodplain, or 25% of the town, or whatever it ends up being.
Well, I heard the mayor said that this, and again, maybe you can direct us on footage, but he commented this entire town is 17 feet above
That's
sea
right.
level. So, and then that's one thing I'd like to point out to y'all from the town council meeting. The mayor said, we shouldn't even be here because we're 17 feet above sea level. So my comment to you back would be, well, 100% of the town should not be in the flood map based on what I heard at town council meeting. And then two, they're obviously going after ag, everything ag, and so ag should be protected. Or not, they're going, when I read this, they're going after everything. Anybody that's ag in this town is going to be under, ag protection is thrown away if this is permitted to touch any part of this town.
I understand what you're saying, and can I tell you with a surety that we're gonna escape from this and there's gonna be no problems? I can't.
No, you
I know,
can't.
I know, based upon what my engineers have told me, South Florida Water Management is working on some revisions to their data and plans that should help us out greatly. So, I mean, I think in the end, hopefully, I'm not being too optimistic, we're gonna be okay. But nevertheless, we may have to still have some regulations in place, or something we could look to, even if there's a smaller percentage of folks in the town who are gonna be subject to the FEMA requirements.
John, but then my question back to you is, what is it, again, I'm a little bit with Howard, what could we possibly have to offer at this point in time to the town council besides saying 100% of the town should be out of
A
this?
determination of whether the town should do its own ordinance or do whatever we can to get with the county.
That's it.
That's the,
County or town?
yeah, that's the central.
An ordinance in relation to what ordinance are we speaking about?
Floodplain regulation. Those properties that are in the floodplain, and they want to, when you're in the floodplain and then you're subject to the firm and the restrictions, if you're going to do any kind of additional building, you have to usually do it through floodplain zoning, building, and subdivision. Subdivision, we don't have to worry about too much, but zoning and building, we would probably have to.
I mean,
to have.
Where I don't understand is, we should be fighting to have the entire town out of the floodplain because we're 17 feet above sea level.
That's what we're doing.
So making a decision which way we go for the percentage of the town that's in the floodplain seems to me to be premature, because it's kind of...
I don't think so. We're gonna have to have an ordinance. And we're gonna have to have an administrative structure established to administer that ordinance. So do we want to fall under the county's umbrella, or do we want to do the whole thing ourselves?
Well, we already
That's-
discussed last
that's essentially-
month that we would go under the county umbrella. That's what everybody's recommendation was it not?
I don't know,
I
this is an
don't
old,
think you did make a recommendation. We've been kind of,
Excuse me, ignorance, what kind of example of an ordinance, what would an ordinance?
the model ordinance.
the model ordinance we gave
It's
you.
in the,
Okay.
You know, the FEMA
it's
wording.
very extensive.
I guess the way I could break it down to you is there are some concerns. I know one councilman expressed to me, this is a lot, this is really bureaucratic. We're really getting into a heavy,
It's gonna be costly to the town. Let me ask a dollar and cents question, for the other committee where I'll ask you this question. If the county handles this, there's no cost to us or very little cost. If we handle this, our lawyer's we're gonna have a field day in expenses.
I don't disagree with that. I hope you're correct on that. I don't know. When you say cost, I'm not sure.
Legal,
Yeah, what the
tax
town- I'm saying what the county
amendments.
may try to do in terms of the agreement. Hopefully, it would be, very similar to the way they do in-progress building inspections now, where we review it, hand it off for the zoning, hand it off to them, and then, but I guess the question there is, if we're going by the county's code, we're not going by our zoning, but their zoning as it relates to floodplain. So that's another question, whether we actually can do the reviewing.
Yeah, well, I'm assuming that the maps that are finally agreed upon are going to be the maps regardless of the jurisdiction
Right.
of the area. So the maps, I'm assuming, will be the same. Whether or not we administer the map or the county administers the map, it's going to be the same map.
Oh, yeah, I'm talking more or less about if they have regulations that they've adopted in the county that relate strictly to flood plating measures, that maybe, I don't know, we might not agree, or, that's what I'm talking about, the nuances of the whole thing.
All right, related to the ordinance, they even call for updated surveys of property elevations and things that are apart from certain normal building permits. But it would be great if we were 17 feet above sea level with a watershed that got the water out of here as fast as it comes in, and that isn't what happens. That's the problem. And that's why the district is focusing on cleaning out the culverts under Okeechobee Boulevard and getting our own piece of equipment to maintain more of a continuous dredging of the canals so that they have the water dissipation capacity that they were engineered to have. And the problem we've got with that being the final argument is that we've got the gates so that even if our canals can deliver the water they're supposed to deliver, it's up to South Florida Water Management to let us deliver it. And those are the coordination issues that it's my understanding that the district's engineer and Steve Yohe are doing the district's part to try and confirm the 100-year 1% flood canal handling capacity. And we may have to review some of the bridge culverts that are in the district if they're restricting the theoretical delivery capacity. And then we're coordinating with South Florida Water Management. We do have, dating back to the 60s, a Corps of Engineers recommendation that supposedly was scheduled to be adopted by South Florida Water Management that would increase our permitted delivery capacity into C-51. Now, that's never been fully recognized, so whether we can get that recognized and how that relates to getting the water out. This is going to be a very important year to take some theoretical water accumulation and water discharge calculations and melding them with South Florida Water Management. And I'm sure South Florida Water Management, the C-51, is going to be a real focal issue because we've got those locks at the Lowe's on Southern Boulevard. And in theory, South Florida Water Management wants to pump water not toward the flood, not toward the sea, but toward the stormwater treatment areas. And how all those priorities get melded together in an argument to FEMA is gonna be a very challenging question.
Yeah.
And Wellington's gonna be involved, and Royal Palm Beach is gonna be involved, and poor old Acreage is really gonna be involved.
Well, I have a question then, as far as, you know, the question versus town versus county. It would seem to me that the Waxahachie Bridge Water Control District is gonna be right up there letting the county know what they wanna do.
We can give them our calculations and confirm the
input.
capacity, but that's input. That's not administering the ordinance. That's the problem.
Yeah, because they don't regulate
And then
permits
there,
and, you know, they do for culverts and things like that, but not as it relates to.
Basically flood control, I mean, you know, water handling, that's it.
So, you're right, though, software water management is gonna be a key, because I think FEMA has a tendency to not listen, look at them a little more closely, and have a tendency to agree with them. And our engineers did make sure that we got a seat at their table now, so they're gonna be sharing stuff with us, and that's a good thing. Or maybe we weren't on the radar before, you know.
the other thing I think would be consistency of administration. That would be the other concern. If you're gonna have someone administer this, you know, if this town, it had, what, 6, 7 years, how many management teams have we gone through? That would be the question in my mind, is the consistency of administration. With the county, I mean, yes, people come and go, but you have consistency of a larger government. Whether you want that or not, I guess is the question.
Is one of the options, I don't know if I'm following protocol here on the question, but is one of the options that the town has an building official that coordinates with the county? Is that kind of a compromise to not totally delegate this to the county, but to keep the town directly involved? Because I'm sure the county's gonna have all kinds of priorities and issues that aren't gonna be necessarily in the town's best interest.
The way most cities that don't provide the function in-house do it is, if they contract out, they may contract out with another community, or what has gotten popular in the last decade is you have a lot of service firms that do that now. With Mike Cosley out of Homestead, there's several in Broward, and what you do is you hire them to be your building official. But that also generally means that you're also processing all the permits and everything, and the county isn't doing it.
It's increasing your costs and your manpower and your
That's it,
storage.
that becomes a big issue.
And you don't even, this town is afraid to wants to be a renter in its own town. You don't have a government building to store this information, so you don't even have that option.
Well, nor the space to.
Right, that's the bottom line.
Yeah.
You can rent something down at the local rental space.
Well, would one step in the direction of coming to some initial input, at least from the committee, be that, you know, we request that the town council give you and Mike Cirillo direction to see just exactly what the county could do, would be willing to do, and how much it would cost?
That direction would be welcome. I mean, we're starting to do that now, but obviously if you provide that as a recommendation, that supports the staff, because he's gonna be looking at that now just to see, you know.
I think in that, John, and that's where I'm leaning toward finding, when they look at this, they need to evaluate for consistency and competency. You know, again, with respect to current management comes and goes, and this is a very serious issue, and we need to have, town council needs to look at the consistency of enforcement of this policy and hiring qualified, educated people in this area, you know, not just somebody says, okay, I'm a building official today, and
Right.
John, you want to formulate that as to a motion?
Yeah, you know, as an initial motion for input from the committee, we'd recommend that the town council direct town staff and town attorney to work with the appropriate county officials to fully evaluate whether they could provide this function, whether they'd be willing to provide it, and how much it would cost.
I second that motion.
all in favor?
Aye.
Aye. 5-0, motion passes. Okay.
So I take it from that motion, you're moving toward, obviously, right, I think you're going toward county ordinance, follow the county, or still to?
No, I think I think we're saying, let's look at strongly evaluate what the county has to offer. If there's any savings, then look at it seriously for consistency. And then there's always, you're always looking at what the town has, but seriously consider what the county has, and because the district's gonna be giving input also, and they always have there's nothing saying that the town can't be in there. That's the plan B, right?
And just as a discussion item related to the motion that's passed, the minutes indicated that, I think Jim mentioned, that the county's initial reaction was that since we did have our own planning and zoning functions, we should have our own ordinance. So how that, because I think they drew a pretty strict line in the past saying that if our planning and zoning was in any way different, as it is, from the counties, that they didn't want to carry out work related to our planning and zoning.
I say this very diplomatic. Sometimes I get the impression, and I'll let Jim make his own statement, so I'm not trying to paint him with this brush too. I think the county sometimes, and we've kind of told you previously, they send us some stuff sometimes that they don't want to deal with. I mean, we've heard, what lots actually grow, that kind of stuff. You're right, they don't really want to deal with us, and especially as it relates to the zoning and the land use. I mean,
But this
if
is
the
a-
Florida Building Code is the Florida Building Code. They can get their arms around that, they don't have a problem.
But this is a time for serious evaluation, and I think this is where the town council needs to see what the county can do on a consistent basis, and if not, then
And
the
I
town
got,
is the next option.
I got the response to my question from the building department, not the county attorney's office. So, so whether or not we can adopt their ordinance by reference or somehow be included in the jurisdiction of their ordinance, I think those are questions that need some advice and direction from the county attorney and our attorney, not necessarily their building official.
Wasn't being rude, I'm listening, I'm just. Okay, next item. Okay, so we dealt with the flood insurance, so we are on to 2.
So if I take it just as a
Okay.
clarification, Madam Chair, do you want us to keep this on as old business, or?
Oh, I'm
do
sorry.
you feel that we're done with it?
Say that one more time?
Do you want us to keep the flood insurance rate maps and the floodplain ordinance on as old business, or are we done with it?
Yeah, we're talking about getting some evaluated input as part of our final
I
recommendation.
mean, before you're done, we'll still, we'll be able to continue to update you, I'll just maybe move it into an update category.
Yeah, that's what, it should be updated, get it off,
Okay. Okay, very good.
put it on the town council, P and Z and. Okay, so, next item is 2, pain management clinics.
Pain management clinics, we have been attempting to collect some ordinances from the local entities here. We finally have them, but we don't have them copied yet. I'd like to defer this to the next meeting unless you all have a desire to talk about it tonight. I'd like to get them to you so you can take a look at them. Clarify anything up to this point that we've told you about. If there are any questions, go from there.
We haven't gotten anything on pain management clinics, right? Are you gonna
No,
give us
I
some?
think what we provided you in the past was just the moratorium ordinance.
Right.
Put in there, yeah.
And I think our concern last time was the true medical need versus the people who just line up the streets to get their pills to sell. And the question was, how do we address?
And you thought maybe we can piggyback somebody else's ordinance who has already prepared one.
For instance, we have hospitals around us, and Wellington was an example.
Oh, the minutes reflected the fact that, we said, let's not reinvent the wheel. Let's try and see what Royal Palm Beach and Wellington have, and if we, it's kind of like we probably can't just say no pain management clinics. That may not fly as a legal ULDC item. So if we have to adopt some regulation, let's, look to the people.
Makes sense, yeah.
Okay.
Howard?
Just one thing I would like you to look into, in realization of the fact that we can't outlaw something. can we tie it to something? Like pain management clinics are only permitted with freestanding, full-service medical facilities?
You might be able to do that. I'd have to research that.
And in which case, that would eliminate these fly-by-night operations.
Mhm.
But we could make it an accessory use only, as opposed to a principal use, and then identify which principal uses that it has to be accessory to.
Well, medical facility, well, a full-service medical facility. I mean, that seems to me to fly, so keep that.
Yeah.
And I thought that was what we kind of discussed last time, was your point last time.
Yeah.
That's the-
Things get lost in one meeting.
Well,
So,
we've got the new medical plaza building going in, whether that would be a qualified facility if it has other resident doctors and dentists. You know, I mean, I guess that'd be the question.
But the issue, it would have to be, in other words, we can't have it so somebody can rent one of the offices in there
Right.
and say, I'm in with a bunch of dentists and doctors, so I get to have my pain management clinic. It would have to be part of the functional facility.
Yeah, the doctor, some doctor in that building would have to be involved, say in a supervisory role or some.
so Jim, have we, you know, what do we need to do to move this on, this payment? What do you know, we've given input, like we said, you know, be consistent with what's around us. Let's not reinvent the wheel. What do you need to hear from us to move this on to P and Z of the town council?
Well, I think if it's your recommendation that we craft some wording to ensure that it is essentially an accessory use, and then come up with some language as to what kind of uses it had to be tied to.
You want to make this motion? Are you?
Okay, I make the motion.
Yeah, you
Yeah.
say it.
I make the motion that pain clinics are only allowed as an accessory use to a full-service medical facility.
Simon, 1 second. All those in favor? Oh, hold on.
On that question, can you maybe amend that motion to make it a little looser so that if it's provided, it's found to be that that's legal? I mean, we're gonna have to look at how we can make it work.
Provided.
Provided
Amend
it's it's legal to do that.
Yeah.
Yes. Aren't we supposed to always say that? Did you say
It's a good
that?
thing.
No, you had said at the beginning, there's something we should always say, and what was that last sentence? You had told us in the beginning, provided, you could
Must
make
have been brilliant.
Yeah, well, good thing that's gone, we're not gonna worry about it, okay.
I'll have to look back and see, but.
Okay, provided, the motion has been amended to show provided that it's legal. Second?
Second.
Okay, all those in favor?
Hey,
Aye, 5-0, motion passes. Moving on to, item 3, ULDC, Article 87, native tree preservation, soil stabilization, invasive exotic removal.
Do you want to take this on tonight, or do you want to reserve this as like your main item for your next meeting? Because Jim has an item that he's going to cover, and Brazen has an item that I want him to tell you about.
Yeah.
So it's really your call.
And I would, because again, I asked you last time on this, concerns me, and I want to bring this to everyone's attention. I believe there is a new state law or state, I don't know proper term, if it's a statute or law, that allows an individual to petition the state, is that correct? In regard to native trees and native,
Ooh, I didn't hear about that one.
there may be something, so I would like time, because I'd like to research that myself.
Yeah, we have to
I think
research
there's some,
that.
yeah, there's something new out there that we won't have enough information tonight to deal with this. So let's,
What would, an individual would do both?
there is a, I believe, John, and I may be incorrect, but I thought something came out in the past 6 months that allows an individual property owner to petition, I don't know if it's, I think it's the state, to allow for removal.
No, that's
Are we-
not it.
Is that not right? No, what,
If
I'm
you're-
sorry,
if
public
you're an
comment.
If you're an agriculture property, you can request from the Department of Agriculture that exemption.
All right, but so a
It doesn't-
landowner,
it's not
if
for
they're,
individuals.
no, so I said landowner, so an agricultural landowner.
If you're agriculture, if you have the agriculture classification, you can request from the Department of Agriculture an exemption. If they determine that, you're doing it for your business, then they will give you the exemption and you're exempt wetlands and all kinds of things.
Okay, I think, and I guess what I'm going back to some of the old, and Jim, you may be familiar with this, the old stuff. I know in the past, people would just come in and clear cut and claim they were agricultural, but I think now you have to ask for the exempt, is that incorrect?
That's an issue that we definitely have struggled
So
with.
let's table this, and let's get some more answers to this, let's table this.
Just as what I recall in our native vegetation thing, we said if somebody comes in as agriculture and they want to clear the area for agriculture, they have to accept almost like a covenant on their deed that if they abandon agriculture, they will remediate to the extent of replacing the native vegetation that they removed.
Well, we haven't gone to that extent, in terms of a deed restriction, but we have had a couple instances where they've had to sign an affidavit.
Okay, all right, so let's table
Stating that
this.
they're doing this as a precursor to.
Let's get more facts and information before we even attempt it. We don't have enough information on what's out there, what's going on, so we will table that, because that's gonna be a detailed discussion. Item 4, is this our earthworms?
Well, before
Oh, no, before we get there, we
we
have,
get into Jim and the Ag, what I'd like, Braden has had an interesting one that's come up, and
great,
And I want him to tell you about it because it actually, ultimately, we're looking for your direction as it relates to a definition of accessory structure, so.
Well, and as it is, we have a definition for accessory structure that basically states that an accessory structure is subordinate in area and height to the primary structure on the property. What we have is a case of somebody that's come in and they have proposed to build a single-family home and 2 accessory units, which are essentially storage facilities that will be much larger than the primary dwelling unit. I'm talking almost 1,000, 1,500 square feet larger, 2 of them, and
is
larger.
that for vehicle storage? What is that for storage? Don't they have to identify the purpose of the building?
They did.
They did.
At first.
Well,
Well, what is it they claim they're doing
well,
versus?
it's flip-flop. They had originally come in with the idea of it being a residential enterprise before knowing the extent that they were going to be limited to 0.01 floor area ratio, which limits them to less than the size of one of their storage units. And then it also defers back to the primary definition of an accessory unit, which means it's smaller in size and height. So they claim they've abandoned the idea of using it as a residential enterprise, warehouse, storage facility, and they now want to store their RVs and boats.
Well, at one point, didn't they tell you they might want to go for some kind of agricultural designation? And they
Yes.
said that's where
Yeah.
they're playing games with ag and they're using ag sometimes to.
They asked
Do
if they
something
were ag,
inappropriate.
if they could skirt the process of getting a
If they
permit.
have horse trailers, right, or if they have,
If they
not
were-
our,
If they had an equestrian use on the property, then they could very well.
you can
Go that
store,
route,
make sure
but-
I'm understanding this correctly, because, so if you have a storage building and it stores an agricultural vehicle, a truck, or a horse trailer, or cattle, or chicken, coop, the chicken trailers,
Earthworms,
what?
earthworms.
Okay, earthworm haulers, those storage, those buildings could be considered ag and that would be acceptable, but the minute you put an RV in there and you're,
What's the RVs for your agricultural
How- that's what I'm asking, does an RV have any agricultural use?
Yeah,
You have
all in trailers.
You might use it, like if you do,
No, honestly, seriously, yeah,
yeah, like people travel with their agricultural businesses.
right.
They go to plant shows, or people go to the fair, or horse shows.
In the nursery, you use golf carts or trailers, sometimes hauling 3 or 4 trailers at a time. You know, the landscape trailers and things that you're moving container plants to different locations for potting.
I mean, if they're really doing something of an agricultural nature, we don't have a problem with that. I
Yeah,
just
but
don't
you
want
have
them
to
to
have
try to
the
say they are when they're gonna do
agricultural
something
business on the
completely different.
property,
Yeah,
You have the, that's what we've all talked about in the past.
I mean, what?
You would have, but you
what's
would
the
have to
business
have that
behind the storage of
classification,
these
or at
vehicles?
least show evidence that you've applied for it,
Right.
but if
Glass?
they
That's
have
what everyone here
no
has
intention of
discussed
doing
before.
that, so.
Yeah, you have to see ag.
Isn't this what we've all discussed before, that you have to
You have to
be ag or show
Mhm.
your business plan?
Well, wait a minute,
So what's the issue?
Glass? Yeah, glass, right.
Glass, well, they're a glass company, currently out of West Palm Beach. And the only reason it raised flags when they came with the plans was because the name was the exact name of the company. in
Well, that's a
West Palm.
commercial.
Well, they were trying to fit it in under residential enterprise.
Oh, come on.
Well, aren't you
They
allowed to
cannot
ask the
have
necessity
commercial
of the height?
vehicles, they
What's
cannot,
that?
if the vehicles are used
Height
in a
necessity.
commercial business,
Well, here's
they
the,
cannot
The
qualify as
height
an ag.
necessity, you mean a variance from the height?
No, the height necessity. You can have a necessity, you can invent all different reasons to have the necessity of square foot floor space. You can't invent all kinds of reasons to need something that is higher than the principal dwelling. Unless you're gonna store 100 tons of hay, which nobody's gonna do in Loxahatchee Groves. It's,
Right.
you're not gonna store your RVs on the second floor.
we couldn't agree more, but when they came in, Braden was handed a building permit for a single-family residence and then building permits for these structures. And remember I told you very early on, we were talking about definitions, that you don't regulate through a definition? Well, unfortunately, on RULDC, there is no other reference to that except in the definition. And so we told them we cannot approve the building permits for these accessory structures because they are,
By definition, supposed to be
yeah, by
smaller.
definition, they ought to be smaller. So, the reason
Unless
why I
you're
wanted
at-
Braden to bring this up to you is, number one, we probably are gonna need to make sure we put some provision that's not definitional in our code that sort of strengthens that situation. Not just, I mean, the definition is fine because it gives you an idea, it tells you what, you know, how you interpret things, but it's not a regulation in and of itself.
Okay, and the reason,
Some codes would limit it to X amount of square feet or smaller than the primary unit, if that primary unit's smaller than, you know.
well, I have a question, and then John, and I will use my famous 3700B road that you and I have discussed, that conveniently his dumpsters have disappeared, that he had stored on flatbeds. He started out putting the nursery has not been maintained, he's got a trailer on the property, and a huge accessory building, and his tractor's there now. So you can have a large accessory building if you don't have a home, right? I'm just looking at all the angles here, or is that
Well,
illegal and nobody's complained against them?
If a home is the principal.
There's no home,
Then that's,
Then it's
then
not an
it's
accessory
not,
structure.
yeah, then it's probably the
That's the
primary
principal structure, yeah.
right, and is that legal? Because they might just say they want to build one huge primary, I'm just looking at this from all.
Well, then it would have to, then you would go to your scheduled district regulations, is to use
What to
permitted
use, yeah.
in that district or not.
Well, I'm just wondering how this building went up on 3700B road is what I'm
Because you
wondering.
don't think it's permitted by the code, is that what you're saying?
Well, I'm trying to understand if it is or is not, and I'm looking at what he's saying, they're trying to use ag, is what you bring up, they're trying to go towards the ag issue, and here's a perfect example. Yes, they wanted to have a house, but say if they take out the house and say, we're just gonna go ag and put up these huge buildings. This has a huge metal, but just like on Okeechobee and B Road too, on the,
on the corner.
yeah, on that corner, they've got a huge building there.
And I guess, I told Braden, as far as dealing with these people, that we're not gonna play games. I mean, I'm making a very simple statement, and that is we are an agricultural residential community, and we embrace agriculture. But I get very upset when I have somebody who's trying to come in under the disguise of agriculture.
That's exactly
It
what I'm
impacts
talking
us
about.
that way by putting in something they're not supposed to have here. So, we shouldn't be tolerating people who do that kind of stuff.
Right, but we already have it, like, I'm giving you that
No, I mean,
example
it
on B
happens
Road.
more than just in that one location on
Right.
the road.
But no, I'm just saying, there's one on the corner of B Road, there's one down at the end of B Road. So
But if they slip by with a permit or get themselves in somehow under the guise of ag, and then
And you don't need a
once
permit.
it's there, we can't do anything about it unless we have a complaint. So all they need to do is slip by the initial groundbreaking, and then they're
Until somebody complains.
right.
I mean, this is such an obvious commercial business.
Of course.
I mean, just tell them, you know, look, come down to Southern Boulevard, or, you know, maybe.
And
Well, they were
we've
inquiring
offered
about,
that.
so they were inquiring about a variance, and you can't really vary from the definition because there's nothing to vary in the definition. Definition just explains what, you know, what the term you're defining. But I'm not really sure, you know, that's a variable type item anyway, because when you start talking about an accessory structure versus a principal structure, you're not really talking about dimensional as much as you're talking about use. The use variances are not permitted.
But Nancy Drysdale's got some perfect property for them in Southern Boulevard.
I guess
Sure she does.
Howard?
I don't understand, somebody refresh my mind on why it's prohibited to inspect these places.
Yes, because you have to have a
Because-
complaint.
Well, no, not necessarily, okay? In other words, if you go ahead and you go to the Palm Beach County Tax Appraiser's Office, file for bona fide ag, get bona fide ag. That office is free anytime to set up an appointment with you to come out and do an inspection to see if in fact that amount of acreage is still being used as bona fide ag, or if it in fact is being used something else. Now, I don't understand why, if Palm Beach County Tax Appraiser's Office can do that, and that is perfectly legal, I don't understand why that when somebody comes to you and says, okay, I want to build this humongous structure for agricultural purposes, for you to ask, just like the tax appraiser's office does, what is it you're doing? Okay, you need something 3 times the size of your house to store your 14 tractors, to do all the work you need to do. The town has the right to do inspections to see if it's really being used and commensurate to the permission given.
Let's jump back a second, because you just said a lot there, and I think we need to break it down. First of all, I don't know under what law or mechanism the property appraiser can do that. He may have the authority by virtue of state statute, I just don't know off the top of my head. But if he comes to your house and you say, I don't want to let you in, I don't think they can force you to let them in. They're going to have to go through the courts and get a warrant or do whatever they have to do. From a code enforcement standpoint, as you know, we have to go through a process. First, we need a complaint. Once we have the complaint, that still doesn't give a code enforcement officer the ability to come on your property without your permission. Code enforcement officers have to be able to find out what they want to find out through a number of various means. Can they go on a neighbor, for example, allow them to come onto their property where they can see what's happening? Can they see it from the roadway? There's a number, but if they go on your property, that could jeopardize any case they're presenting because they don't have under law the authority to do this. Building folks don't necessarily have the ability to do that either, except in the case of when it's in progress inspections. Then they can. If it's a case where a building official suspects there's a problem, he can try to, with his authority, because the building official is a very powerful position in local government, to try to get in, or they can, again, go to the court and get the warrant. But there's a whole bunch of private property rights and things where, government officials just can't come into and invade your property. They have to do it within the property.
Okay, so can permission, when somebody comes with an obvious questionable situation, can you go ahead and tie the town's right to periodic inspections to the approval? We'll give you this if you agree to let us inspect
That,
once every 2 years.
Let's take the example of this issue we're talking about right now. If we indicated up front that, say we suspected that they were going to do something else than what they could be doing in an accessory structure, and we asked them what they were doing, and said, oh, we're not going to do that, we're going to do A, B, C, and D, that all appear to comport with the law. And we say, okay, well, we're going to hold you to that, and we might try to put some kind of proviso or caveat in there. But where the town gets hurt is then we lose control. We've done the zoning review, and it's up to Palm Beach County to some extent to follow through on that. So our faith is tied to them. Now, let's say they build it out and they don't do what they told us they were gonna do. Now, we're almost like in a code enforcement situation, which is never very good, because now it's tough to, you're either getting a complaint for somebody, oh, they told you they were gonna do A, but they're actually doing B. And it can get problematic that way.
I'm still kind of lost in that.
Okay, where did I lose you?
If somebody comes in with an obviously questionable
Use?
idea, like Brandon
Or
just,
use, yeah.
okay,
Mhm.
you can tie the permission to them signing
An affidavit?
an affidavit
Mhm.
that they will allow one inspection every 2 years for the next 10 years, just throwing out numbers here, okay? In order to see that the building is being used in a way as presented when the permit was gotten. Now, and if in fact it is not, then it's a code enforcement violation.
I agree with your scenario. If you could do that, you could probably do that under the law and be okay. I'm going to tell you though, chances are, if the person is not intending to comply in the first place, they're never going to sign something.
Exactly. So in other words, if I want to build a barn that's 3 times the size of my house, and I'm truly going to use it for agriculture, and I decide to change it and not use it for my tractors, but to do hydroponic gardening, okay, I'm not going to mind and one inspection every couple years to see that it's within the parameters of what I promised.
Yeah.
We're just
Probably
not
right.
that secretive when we do these things.
I agree.
So I don't understand why that would be a problem to.
Because you're talking about the good guy, the guy that's going to cooperate. A lot of times we deal with the guys that are trying to get around them.
The guy that's trying to get around is never going to sign on to being inspected.
And I have no way of making them. That's my.
Well, no, you just don't issue the permit.
Provided I have the proper codes that back me up, I can't go on a suspicion.
Well, no, before the code,
Yeah.
you've got the land use.
In this case, we have at least a definition that says, no, you can't do that.
Okay, you sit down and you figure out what square footage of storage space is necessary for a 10-acre parcel to do anything. And if it goes above that percentage of square foot on 10 acres, then it falls under the questionable category.
Why are you saying 10 acres? Just as a-
Well, I'm just throwing a number out.
Oh, okay, I thought that you had some.
In other words, if somebody's going to want a 10-acre agricultural use, and they're going to put 5 acres under roof, and it's not hydroponic gardening, then you got to go, hey. So I think there could be a formula there, just like you already have a formula that says an accessory structure has to be less square footage and height than the primary. And I would immediately disagree with the height, because it's common for people to have barns that are higher than their house. But then again, that loft is usually for things like hay storage during the winter and whatnot.
Right.
Right. But if you had a definition giving it X square footage and X height, then you could get a variance from those height restrictions for your barn.
Yeah, that's
Because
one
you'd
way.
be proving that you need it for a valid use, but if you needed a
You
variance.
prove the hardship. Variance is based on
But you
hardship.
can't come in and get a variance for a glass factory, because the council would never approve it.
It's use related.
Right.
It's not dimensional or.
So that would be my suggestion, to figure out some logical formula to go by in relation to square footage of land versus square footage of storage facility that they want to build. And say, once it goes beyond that threshold, it becomes questionable, and we require an affidavit allowing us to do an inspection to make sure the facility is being used as promised.
Just as a matter of course, I guess I'm asking you guys, do you believe there are a number of uses in the town that are hiding under ag and not really ag?
Okay, this is a joke, right? 3700 B Road, Okeechobee Boulevard and B Road. Let's just drive, we will all drive up and bring you a list.
Nobody's telling us.
No, I sat at the FAAC meeting, and I specifically said, when we had that discussion about, I'm on another committee, financial committee, we had a discussion about what is holding property values down, and Mark was brave, and he said, oh, I think it's ag, and I said,
I did not say it that way.
Well, I was gonna, he referred to ag, and I said, I think what's holding properties back here, we know that ag communities can be very expensive, beautiful communities, with forest trails, et cetera. I believe what's going on is we have a lot of properties here masquerading as ag, just as Brady is seeing it happen. And I think every one of us could go up and down the road and come up with a few addresses, but we don't want to be doing, and that's the problem, you don't want to be the ones complaining.
Like we've got junkyards out here, you know, they're towing people that have been here for a long time, now they're gonna claim it's legacy. But, you know, I think they ought to go before the
I think that's an
town.
aerial of that place.
3,700 vehicles.
Chobe's like,
Well,
Yeah, it's north. There was a dumpster in the road yesterday.
we're 3,700
Yeah.
feet. Oh, yeah, yeah.
2,000 is Okeechobee.
So it's north of Okeechobee.
Yeah, so it's 0 to 2,000, 2,000 to 4,000.
Okay.
There's 20 acres in there, their building does show up online.
They're what?
The building does show up online.
It's 3,700 B Road.
What do you think it is, or what,
What do we, well, there's a lot of things going on there. Well, we can only imagine, but it seems to be they own, and I bet you know, it's interesting how you bring up a business. I believe that gentleman, he lives in Wellington, and I believe he may in fact have a business that's in waste, or he provides dumpsters. What do you call that? When you provide dumpsters, when you have, big tractor trailers hauling the big,
sounds like a commercial concern.
Is that Jeff Holland?
that might be it, jet hauling.
Yeah.
And then,
He's the guy that went in the canal.
right, yes, yes.
Yeah, that's Jeff, he lives in Wellington, and, you know, he has a lot of these clamshell hauling trucks. One of them went in the canal and was a problem, you know.
Would that be a commercial concern, masquerading as an ag? I think so.
Because they did put a bunch of plants out there and little buckets and
They
they put,
have, but they're not
and put little
maintaining them.
sprinklers, and I mean,
Yeah, they're not.
it can't be an acre of plants. And then they put up an office.
Just like that business at the corner of Okeechobee and B Road, they planted some palm trees that are now growing up, but they planted
The
them
cattle.
so they were a nursery, and now.
And they paid most of the property.
All right, look, what we
Well, let me
need.
ask my question again, because I think you guys, I said ag uses masquerading as ag uses and doing something else. I think, yeah, I know, we, in the town, we're aware of a
3,700 feet.
lot of uses that are, have been plopped here that aren't, they don't even
To
pretend.
answer your question, yes, there is a lot of
Yes.
people that are hidden.
I agree, I know there's a lot of those, but I'm,
I think we have to determine if the town is permitted to ask the Palm Beach County Tax Appraiser's Office to investigate something like that.
yeah,
That was your first statement.
yeah.
That's it.
And then Braden, did you have a suggestion of a definition?
Then you don't need a.
well, we have a definition, I think we need to.
We're talking about, we
address them
probably need to put a provision in.
in like the residential zoning district. Specifically a section on accessory structures, and then provide height and specific height and size limitations.
So like if somebody wanted to have one huge RV that, you know, has the huge bus and they want to have a shed for that, they could probably do that, but you're saying you can't have mass storage for large residential vehicles?
Well, I mean, like this person's home was 1,800 square feet, and each storage unit was almost 3,000 square feet. So, I mean, it's.
Well, I know of a property like that near 99th, near the Corbett, and the gentleman refurbishes vintage vehicles, is what he, but they have a huge house also, that's probably the same size as their storage unit, they refurbish vintage vehicles, but that is a,
Well,
Yeah,
you know,
I
our
can
point
see
out
that.
here is we've got legacy businesses that are gonna be dealt with maybe one way, but we certainly don't want to encourage new businesses to come out here and masquerade.
Right,
Right,
people have
exactly.
buggies out here with big toys though.
Right.
Buggies and.
see, and that's the other side of it, that's what I'm
RVs
thinking
and
of, somebody has an RV, they have the buggy,
I mean,
and,
if you have a airboat, a buggy, and an RV, that's a big garage.
Well, yeah, there are legitimate reasons to have an accessory structure that's bigger than your home. And,
that's where you ask for the variance.
well, yeah, that's where you would put a variance provision in, because somebody may be, like you said, an avid vintage car collector, or something along those lines, and they want to have 10 cars that they keep in their garages. And their garages, but even if they have a big mansion, the garages would probably still be bigger. That's where they would tend to get the variance from. But on a normal circumstance, I mean, you have somebody coming in just to do generally a single-family home, if they have accessory structures that are much larger than that, that's not normal, there's something going on. That's
Well, I
typical.
think that the tricky thing is somebody comes in where they don't say, we're in the glass business. we're just, hey, I want to build a 2,000 square foot house and I want to put a 10,000 square foot barn out here because I have antique cars. I think the guy should, if he's on 5 acres, I don't see where that's an issue. He should be able to do that.
Yeah, I agree.
They can kind of sort it that way.
But you gotta have a standard to regulate it by.
Right.
See, there's no
Very
standard.
wrong.
All it is a definition, which ties our
By
hands. All we can say
definition,
is,
you can't approve it.
can't approve it.
So how do you create the standards?
So you're in agreement, that you want to do a motion on that then? Does that give us direction so we tell council?
Well, I guess the question we still have a question is what we're making a motion on, Mark, is.
To create a
To
standard.
create
Yeah.
a standard in the zoning code relative to accessory structures versus the principal structure.
Okay, right, where we don't, the point is, as Beth just said, you don't want to prevent a private individual, not, we don't want to encourage commercial businesses coming out here, but we don't want to restrain a private individual from using his property.
And you would write an exception in there, where you would
Well,
identify certain exceptions and write that.
Or allow the,
Well, let me ask a question. It's not that it's wrong for him to be able to put those accessory buildings. It's the use that was grouped.
whether it's personal or
No,
commercial.
well, even if they were personal, by definition, you can't put them
That's what it says right now?
in.
They cannot put it in.
By definition, his accessory structures cannot be larger in area or height than his primary structure, would be a single-family home. But if there was a set of standards as far as dimensions or percentage or anything, then he could apply for a variance from that. But you can't apply for a variance from a definition. Because then everybody would come in and start applying for, I want to vary from the definition of I don't know, commercial.
So what you're saying is that we need to set a standard so that people can do this.
And we can take a look at those that are like the more common, like garages for somebody who's a car collector or something like that. You can send that out. So, because, I mean, you don't want to start making everybody go for variance either. That would not be the intent.
Well, it still looks to me like we know this guy wants to put a commercial business in an ag-res area. And we really ought to tell him, go down to Southern Boulevard where it's commercial.
Well, yeah, I mean, it's already been suggested, but,
And just tell him, no, you can't put that here. You
You
can't
have to
disguise
right,
it.
well, they're claiming that they've now signed a lease on another property where they're gonna move their business, but now his sister is gonna live in the home and she has an RV and boats that she wants to store.
Her personal.
Mm-hmm.
But now if they start running the business out of there, now it's illegal because they're not allowed to run a business.
Correct.
Forget about having the buildings, but somebody has to turn them and say, hey, these guys are running a business.
Right. Well, I mean, to run a business legitimately, and our glass company supposedly it's been around since the 50s, they need a business tax receipt at that location. If they come in for one, then they don't get that approval, so. I mean, there's another,
So give us direction on the type of definition you would like, not definition, but
well, we just need I think we need a motion to come up with some sort of standard for an accessory structure.
okay, I make a motion that we come up with standards for accessory structures.
Sounds good?
All in favor?
Aye. Why don't you just say that at the beginning?
They've been saying that for a while.
Did you know?
Although,
Who's the seconder of the motion?
Beck can elbow her and make her talk louder. Okay.
And that's presuming he doesn't come in under some sort of fallacious ag purpose.
Yeah, my concern
Yeah.
really is, the commercial, when you do that, how do you keep the commercial? It's,
When they start their business, that's where you get them.
I don't know.
Well, I mean, he still could do a residential enterprise but he'd have to, again, you have a business tax receipt, you'd have to have a homestead exemption. And his accessory units, he's allowed 2 of them, and combined, they would be, his acreage, he would have been limited to 2,300 square
But
feet.
apparently he's not gonna live there, his sister's gonna live there.
Right.
So he can't get a homestead exemption.
Well, unless, right, and I'm not sure who the property, which
Or he
person's
could
name
get
is
it
in.
rented to his sister.
But if
We
he
can't have a
doesn't live
homestead
there-
if you're renting it.
Yeah, if he rents it out, you can.
no, we're gonna be watching him then, aren't we?
You can't have a homestead even if you're not renting. I own 2 properties side by side that are part of the farm. They won't give me a homestead on both of them,
Yeah,
You
you'll
can
get
only
another
homestead
one.
one property.
One.
Oh,
and I'm not renting it,
yeah.
Okay, now can we get on to earthworms?
I don't know that was about earthworm.
I don't think that's what let's talk about.
Oh, wait a minute, does Jim have one, or is this Jim's topic?
Yeah.
Is this Jim's topic?
Yeah, this is mine now. I don't want to get into the permaculture and round beer bottles like we did last meeting. I'd like to make this a little bit more general discussion on ag, and it really goes back to Howard's motion.
So what page are you looking at, so we can be with you?
At the minutes, that would be 8 of 9.
8,
8 of 9.
Howard's motion, Howard's just causing all.
Well, it was a motion that was made, but
We want to get back to that today.
but it was deferred. I mean, for future action. And the motion was that we go through the ULDC, and essentially every time we see the word agriculture, we just delete it. And staff was uncomfortable with that approach. But at a previous meeting, Howard also mentioned that he would like to see staff sort of come up with a compendium or summary of all of the state statutes and regulations that relate to agriculture, so that under one cover, we have a clear, concise document of what the Florida statutes directs in terms of agriculture. Now, it's my thinking that we only have maybe 3-4 meetings left before the committee sunsets, not to say that it might not be continued, but I'd like to suggest that we make agriculture, the issue of agriculture, the focus of the rest of our meetings. I've gone through and I've identified 14 Florida statutes that address the issue of agriculture. And I've gone through these statutes, and there are 22 different terms that have the word agriculture in it. So we have all these statutes, and we have all those definitions. I'm proposing that staff put together a summary compendium or whatever of these of the Florida statutes and definitions of terms that we bring it back, and we use that as a basis to go through the code to see what sections of the code might need to be deleted, what sections of the code might need to add specific references to Florida statutes, so that when you see a term in the code, rather than wondering what that really means, we have a statutory citation that we go back and we can tell exactly what is meant by that term. And sort of take that approach, take that as our approach as to how we address the issue of agriculture with this committee.
Okay, I'd like to say something first, and then Howard and John, and I'm sure Beck and Katie will chime in, because I distinctly remember Beck made a comment, 2 sentences that addressed his opinion on this, that something like if it was ag, then it shouldn't be even touched in here. I thought it was something we discussed. And I believe our very first meeting, I made the comment that I didn't think anything, ULD should have nothing to do with ag, and I think 2 meetings ago, Mark and I had a little discussion regarding development, and it is my understanding that Florida statutes dictate that ag are not development, and ULDCs deal strictly with development, so I'm a bit confused, one, as to how the town even has jurisdiction to even touch ag. I realize, and let me say this, I realize these ULDCs got created and ag got in there. I'm not saying the attorney that supervised this was correct in allowing this to happen. That, this is a nice little legal paycheck for a law firm by having ag in here is how I look at it. So just my opinion as I've said from day one when I showed up here, I don't think ag should even be in this book. I think the state statutes deal with it. I do respect your work, and if you want to present that, that's based on the rest of the committee too. I understand that it's here, we might have to look at it, but my opinion is Florida statute makes the rules, and I really question the town's legal authority to touch ag.
Okay, let me give you just a very basic example. In our AR zoning district, we have 2 permitted uses, agriculture and bona fide agriculture. You know, exactly what does that mean? We have Florida statutes that define both of those terms. And if we have that as a use in our zoning district, it's my opinion that we need to know exactly what those terms mean.
Why can't we just say they mean what the Florida statute says they mean?
Because I think we can say that, but like I said, we've got 14 statutes that address agriculture. And it's very difficult for the staff. When all of these different requests and proposals as to what they want to do with their land when they come in, every time something comes in, we have to research on Florida statutes. I think that it makes it much simpler, even if we have a supplementary document like I'm talking about that gives us a
That
direct resource.
educates the land planner?
Yes.
Okay, that you're trying to,
Yeah, the land planner and the property owners and the residents of the town.
all right, Howard, and then Kami, and then Jim, because I know you're gonna say something.
Okay, Jim, I disagree with you, and I'll tell you why I disagree with you, okay? That can be handled by ordinance, that can be handled by reference to the state statutes, but it doesn't belong in the ULDC. It is not development. It needs to be handled in a different way. Now, we can go ahead and we can spend all of our time chewing away at the agricultural issue in this ULDC committee and ignore all the other nuts and bolts things that we could have fixed, okay? I have something sitting right here that was brought up day one that we've never even gotten back to, all right? Again, it doesn't belong in the ULDC. I'm not saying it shouldn't be addressed in some way, somehow, by town management, by town staff, but it doesn't belong in the ULDC. Now, the moment that you start wanting to put references to the state statutes in the ULDC, other than a blanket statement that agriculture is not in the ULDC because it's all regulated by state statutes, anytime you want to do any more than that, you are in fact regulating agriculture. And I'll give you a perfect example, okay? John Ryan is going to say, in order to be agriculture, you have to be BMPs. I'm going to point to the part in the statutes that says nothing about BMPs, but just says standard practice for the industry. Whoever decides to put which of those two in is in fact regulating agriculture in the future in this town. And I realize it makes everything a lot more difficult for you, but it also gives us the ability to get through this ULDC and fix all the things that need to be fixed that have nothing to do with agriculture. If we get involved in that, we're in a never-ending argument about what should be in there and what shouldn't be in there, what phrases should be chosen in order to illustrate what we mean. It doesn't belong in the Unified Land Development Code. That's the bottom line of the whole proposal.
Let me ask you a question.
Yeah.
So, in the AR district, under permitted uses, we should take out agriculture as the permitted use.
No.
Well, that's what your motion last time was.
We just say agriculture means what the state statute says it means.
That's it. That's it.
That's what we say.
Plain and simple, no examples, nothing else. And then we can put together a ULDC that does what it's supposed to do. I know it doesn't do what it's supposed to do in relation to your thought. Don't get me wrong.
But he's the one in the position though, of being the land planner, having
Really, it's Braden.
Well, Braden, yeah, they are in this
Is the one
position.
that's
We
stuck
hired
with
this
these
management,
Difficult
right.
decisions daily.
Well, that's what you need.
Well, if you take out, I've been quiet, so
Yeah.
if you take out all references to agriculture, you really have to redo the whole zoning code and plan. Because 98-point-something% of the town is AR. You can't have agriculture, residential, and take out agriculture. You got just residential.
You can't take out the word agriculture, but as far as using this document to regulate what you can do and cannot do. Perfect example, we moved commercial equestrian facilities out of the special exception.
But Howard, it's just not a word. You guys tied ag and residential together at the hip.
Howard,
It's not just that, if you say ag,
I agree with what they're saying. We have to have agriculture in there somehow. So we cannot just take the word out
no.
and just
So if
disappear it.
Jim-
I agree with you. I agree
Yeah.
with you.
But here, the
Hold
first,
on, Kayla.
Okay, so I understand why it has to be in there. It makes sense, just like Beck said. But I think our biggest problem is, and I don't mean any disrespect or anything, but I think we need somebody in your office that understands agricultural properties and understands our town. Because if we had somebody in your office that has worked in agriculture or in building, and if you understood the state statutes and all that, everything might run a lot smoother. And I do think that we need to refer to the state statutes in there, rather than us trying to develop all verbiage and everything. And I don't think that that's a good idea.
no offense taken, but I will tell you, even in the property appraiser's office, they had one guy who had one opinion on it, on how ag affects them, and now they have the other guy who has a completely different opinion. So, I mean,
So what,
the opinion is in the eyes of the beholder.
I just think somebody that has, with more agricultural background, I think it would be beneficial.
What
I
about
think you
if,
guys should hire another person that,
what if we amend the motion to say
no, I don't need another
Removal.
job.
removal of any references or phrases that would interpret state statutes in relation to agriculture?
Say that again? That one.
Removal from the ULDC any verbiage that would interpret the state legislature, the Florida statutes.
Can you give me an example of what you're talking about?
I'll give you an example, and Virginia's denied me.
Oh, no, I'm sorry, John,
See, that's why I don't like those things.
No, John, I'm sorry, I apologize, because you guys don't take them back, that's where I get confused, you put them out there, don't take it back, go ahead.
In the first meeting, I handed out some verbiage that I thought ought to be in the ULDC. I think it's easier than what you and Howard are trying to dialogue to accomplish. I said, with regard to agriculture and the Florida Right to Farm Act, the town's ULDC must defer to state statutes except for any specific and legally established exceptions like environmental, water conservation, and quality. Now, I said, further, the town ULDC should not attempt to preempt the state legislature, Florida court precedents, or the Florida Attorney General. You know, I mean, we just make a real simple statement that the town is not attempting, as Howard says, to interpret the statutes as they with regard to agriculture, because they're going to change. I mean, we've got a situation now where the property appraiser has decided to do something different than what they were doing before, and it's going to go before the Value Adjustment Board or a circuit court. And there's going to be determinations that are completely apart from Waxahachie Groves, and we ought to just stay the hell out of it.
Well,
What is
John,
Could you elaborate on that a little bit?
What I was just saying?
Yeah, and I just thought you were done before, go ahead.
Well,
As an example of what they're gonna be doing.
the example I was talking about that's being handled, well, the county property appraiser in the past regarded agriculture as agriculture. They've now changed and said it's like operating a dog kennel, you know, and over and above that, it's regulated by the Fish and Wildlife people, not by agriculture. So the property appraiser sent out notices to the agriculture people in Waxahachie Groves, and I presume elsewhere in the county. He said, you are no longer so your bird raising considered agriculture. The letter also stated, as has been on the blogs, that the recourse is to go before the Value Adjustment Board and argue your case, or to go before the Circuit Court in Palm Beach County and argue your case. Now, a lady agriculturist out here tried to go before the Division of Administrative Hearings or the Department of Administrative Hearings, and as of a couple of days ago, they appropriately told her, no, you don't need to be here. As you were told in your letter, you need to go before the Value Adjustment Board in the county and see if they'll change their mind, or you need to go before the Circuit Court in the county and see if they'll agree with you. Because the Florida state statute that is mainly involved is the one that says the property appraiser is the one that makes the determination of either agriculture or not agriculture.
Actually, I want to disagree with that because the state of Florida has said they're not the ones that make that determination. The state of Florida does, and they basically feel that the property appraiser's office has gone rogue. They are, the property appraiser's office.
Be specific. Who is saying that on the state level?
John Costigan, for
Oh,
example?
Costigan is.
I know, you don't like what he said, so you don't.
No. He's going to be withdrawn. He has no authority to make the accommodation letter to the lobbyist that he did, and it'll be withdrawn.
Well, the bottom line is that with the meeting at the tax appraiser's office, it was stated that they were forced into doing this, but they would not basically go into detail as to what or how they were forced to do this. The bottom line is, it is being appealed, and it has always been considered agriculture. Okay, so again, the main point John is making, which I agree with, is things are always in flux and they will always be in flux.
All right. Jim, back to, let's, go ahead, Mark.
Can I make a comment on that?
Yes.
That was,
Now I'm actually going to ask the public for comments,
all right.
because we haven't,
Well, this may sound strange, but I agree and disagree with John. I agree with the statement he read. We've never had a problem with the statement. We should,
which the first one?
yeah, as call us regulators, call us whatever you will, I can think of facilitators, but we should never be interpreting things inconsistent with the statute unless it's an honest mistake on our part. But there should be no premeditated reason, why you're gonna try to go against the state statute. But to say that we're not gonna even address it, we should just wash our hands of it, is like every city and county in this state is doing interpretations and dealing with ag, because there are so many statutes, and when you have so many statutes dealing with an issue, that's what you start to have. But everybody's interpreting what
And just
happened.
because they're interpreting it doesn't mean they're supposed to, Mark.
That's not what I said. But if you can't say, okay, blank check, we're not gonna touch it, we're gonna let it go, because then you're gonna be sorry if you do that.
Right.
Because eventually
Well-
you're gonna have somebody that's gonna burn you back.
Well, I want to get back to Jim, what Jim was suggesting. And we have, everyone here supports ag in some way. Okay. And then we have the idea that, okay, we could throw ag out of here and just go with the state statutes. But then you're telling us, and again, I just have a hard time with this because to me, ag should not be in ULDCs because it's not development. But you're saying as land planners, you have to address this, and you're suggesting creating a discussion, putting something together for a discussion for the purpose of, and that's what I'm not understanding, for the purpose of,
For the purpose of using that document as the basis for going through the code to determine what needs to be deleted and what needs to stay in there. Or if we need to make some changes that reference the Florida statutes, we have those Florida statutes available to see what we're referencing.
I think what
I
we're-
see you, John, go ahead.
Yeah. I think what we're in agreement on is that we don't want to interpret the Florida statutes.
Right, we agree
Other
on that.
people have that responsibility, not us. Just because you have the word agriculture in the ULDC doesn't mean you step up and say, well, this is our interpretation, but somebody else may interpret it differently. And I think a general reference to the fact that agriculture is primarily determined by the county property appraiser per the state statute, and that beyond that, there are all kinds of agriculture restrictions that are part of Florida statutes, really a web of Florida statutes, and those are going to be determined by other people.
That's absolutely correct, and let me give an illustrative example. Isn't the way you look at agriculture in a town like Waxahachie Groves different than the way you may look at it if you're in West Palm Beach?
Sure.
That's all interpretation.
Yes, but does the town of West Palm Beach have an AR designation?
Right.
Or the town of Palm Beach, that would be even better. Does the town of Palm Beach have an AR designation on what's
No,
on?
they don't, that's why we're.
Well, let me comment on that, excuse me, let me comment on that. When I lived near Southern and I-95, before it was on 995 growing up, that area had an AR designation. And pardon? Right.
Yeah,
That
county doesn't
area
have
had-
an AR zone, yeah.
Right,
Yeah.
that was an AR zone, and even when it went away, you couldn't have horses anymore, you could have chickens and rabbits, and then the city folk complained about the rabbits, and that went away, okay? So the AR zone is significant and does cover, has value, you know?
What I was saying is the interpretation. That's what John was keying in on, and that's what I said. It's different from jurisdiction to jurisdiction. We have a whole different approach on ag because we embrace it, and it's the majority of our town.
But that's my concern, I guess my question is, why is there a different interpretation? And that's what we don't want to get into, interpreting ag, and Florida statutes define it. And I do have a concern about the property appraiser, but.
And that's what I wanted to address.
Go ahead.
Again, there was the exact issue I'm trying to bring up, okay? An issue that, a statement that you said that's correct, but I don't believe you were saying that's correct, that part of the multifaceted statement, okay? It's not the property appraiser's office that determines whether something is agriculture or not. That's the state of Florida, that's the state statutes.
No.
You can go ahead and you can have
So
a,
you guys have a different interpretation.
okay? You can go ahead and you can plant 20 acres of corn to grow and sell, and nobody's gonna argue that that's agriculture. You are not forced to go to the property appraiser's office to get tax protection in order to be a farm and that to be considered agriculture. If you choose not to do it, that is your right. And just because you don't do it and they don't have you green belted for one reason or another, doesn't mean that growing corn is no longer a bona fide agricultural pursuit. So the moment you go ahead and you say, it's up to the county tax appraiser's office to make the determination whether it's agriculture or not, you are in fact regulating agriculture. Just by choosing that verbiage, because you automatically eliminate any bona fide agricultural pursuit that chooses not to go before the property appraiser's office or is out of style with the property appraiser's office this particular year. And that's the issue that I have with this whole thing.
You know, I mean, it's real simple. The first item, Florida Statute 193.461, property appraisers shall on an annual basis classify for assessment purposes all lands within the county as either agriculture or not.
Right, for assessment purposes. Doesn't say making the decision whether they're bona fide ag or not. It's for tax assessment. John, you were the one that argued incessantly, nonstop, at the agricultural meeting a couple of years ago that they're a taxing authority and have no right to determine what is agriculture or not. Do you remember that guy?
Listen,
The state statute also says that
Let Katie speak.
local and town governments can't override the state. So if you do have a problem with your local government, be it Waxahachie Groves, Wellington, Palm Beach County, you go straight to the state with your problem, and the state makes the final decision. It says it in the state statute.
right, but the state statutes also defer to the determinations made under 193.461.
For tax assessment.
Okay, we have.
No, not for tax assessment, for Florida right to farm.
I have a feeling we're going to continue this discussion. We do have one public comment, and then I wanted to get back to what Jim was talking about. Todd, would you care to?
Yes.
I got it off track, sorry.
This code book that you guys are working on is Unified Land Development Code. Now, correct me, Jim, if I'm wrong, but the Florida statute says agriculture is not development. Is that a fair statement? If agriculture is not development, why is there anything from agriculture in our land development code? That's where the hiccup is. Nobody's saying you can't regulate it or something somewhere else, but it's not development, so it shouldn't be in the development code. That's the point.
Well, it's a land use,
Okay?
okay, and land uses are in our code.
Okay.
That's where you're
But-
talking about agriculture residential example.
But if the land development code is enacted according to Florida statute 163, and Florida chapter 163 says chapter 380 is what defines development, and agriculture is specifically excluded, then that says you can't do anything with agriculture as it relates to this, because Florida chapter 163 is what you adopted this under. How do you explain that? I mean, I understand what you're saying about the zoning and all that and land use, but how do you get around that? When Florida statute clearly says agriculture is not development, so you can't put it in the development code.
See,
Well,
that's kind of
well, like I
what
said,
we're
I mean, the zoning portion of the land use code deals, the zoning portion of the ULDC relates to land use, and that's why it's in there.
Should there be two separate, should there be a land use
Call it code
code
ordinances.
and then a development code?
Yeah, well, I mean, we can take the word development out and call it the Unified Land Code, if you want. I mean, it's just a matter of semantics.
Well, is it a matter of semantics when, I mean, the town attorney said they've adopted the ULDC according to Florida chapter 160, I don't know if it's 162 or 163. Well, if that's the law that they use to be able to adopt this book, and you go to that Florida law and it says you can't deal with agriculture in that, you can call it a Unified Land Development Code or regulation or whatever you want to call it, but the town still adopted it with the authority from Florida chapter 162 that said you can do this. No matter what you call it, you still did it according to that Florida statute. And that Florida statute said you can't reference agriculture in there.
I don't believe it says you can't reference it.
It says that agriculture is not development. And if this book is
Well,
only related,
I'm saying agriculture is a land use, so it can be in the zoning code, portion of the code.
Okay, John, did you have something to say? Okay, thank you, Todd.
yes,
John, do you have something to say, or you're, because you didn't know if you took it back or what? I don't want you to think I'm ignoring you there.
I just, I'm
See, that's, okay, thank you. That's what I was trying to say. Howard? Yes.
Okay, I'm still going to optionally come forward with a motion to remove all verbiage from the ULDC that regulates agriculture in any way or mentions agriculture other than reference this, the state statute or the land use. That's it.
But, okay. Jim?
Well, I actually brought this up to try to bring this issue to a head, because it seems like we've been spending a lot of time in debate as to how we're going to address this issue. And I brought this up to see if the committee wanted to get into more detail and pursue it, or do we want to pass a simple motion saying this is what we want to do and that's the end of it, so we can get on to some other issues that the committee might want to address.
Oh, that was your Katie?
No, close for me, but
Okay.
give us an example of one thing in specific, because we're being real hard-headed saying, no, we want it completely out, but I don't think you've come out and said, okay, this is like a situation like this. I understand where you talked about the earthworms and the glass and all that. But something where we need to address it more, that you're wanting to cover. I mean, there's, like you said, there's 14 different statutes there.
Yeah, well, the biggest issue that I've always had is that, and it gets back to the definitions of bona fide ag and who does it, who signs that and when. I've always felt that there's a gap in between when a property owner proposes an agricultural operation and the time that he gets the bona fide ag designation.
Which is what you just went through, you're going through.
During that gap, or hiatus period, does the town have any role in guiding, regulating, controlling what happens on that property until the time that he becomes bona fide ag?
I would say no. If they build something that isn't ag, then yeah, then the town needs to regulate it. But if they're building something on the auspices of ag,
Yeah,
if they're building a horse barn, for example, which is a good example, they buy a property, it's just AR, it's not bona fide ag within the county, they start building a barn. Should the town regulate that? I don't think so, because that is an ag structure.
Yeah, well, I mean, my opinion is that we shouldn't necessarily put ourselves in a position of having to rely on code enforcement every time something comes up. I think that we should have some ability to look at a project up front, and even if it's through signing of an affidavit saying, stating this is what I'm going to do. If it comes to code enforcement, the signing of affidavit with some conditions in there gives the town the ability at some point in the future to go back and enforce that affidavit.
Hold on, let's just take one more public comment, get the public comments over with, because I'm gonna try and wrap this up a little bit. No, Katie, I saw you, Katie, you're done, we're gonna be John and Howard. All right, public comment, Thais?
Well, my personal opinion about removing every wording that it's related to ag, I don't quite agree to that. Putting the Florida statute leaves that completely open for interpretation, because that's one of the issues we've been having. That, we, the people, are coming with the Florida statutes, and the interpretation, the attorney's interpretation, it's different. So if you put the Florida statute, you leave it open for the interpretation of that Florida statute. Now, I think that one very important thing would be to find exactly what is the difference according to, we all need to agree if there is a difference between agriculture and bona fide agriculture. According to the town, bona fide agriculture, you have to have BMPs, whatever, you all know what's going on with all that. So if there is a difference between agriculture and bona fide agriculture, and then the way of putting it on the ULDCs, I would just say agriculture is exempt. And I wouldn't say bona fide agriculture, because my understanding is that exactly the same thing. Because I can have a farm and, harvest vegetables for my family to eat. And it doesn't make it necessarily commercial, but it's still agriculture.
And bona fide ag is commercial, as Beck, I think Beck had that discussion several.
Well, yeah, they kind of like to make it think that way, but it's not really, there's not really a difference.
Okay. All right, thank you. John, and then Howard, and then let's try, you guys, do very short and quick, because I want to get back to Jim and make a discussion. I know there's a motion, Howard has made a motion.
But I had a comment for Jim.
Okay, let's go with John real quick, and then Howard, and then I want to wrap this up.
Further in 193, 461, it says the term bona fide ag means good faith commercial agricultural use of the land. Lands that are used primarily for bona fide agricultural purposes shall be classified as agriculture. In other words, the property appraiser is using those terms interchangeably. He's saying if you want an agricultural classification, you comply with a bona fide agricultural purpose, which means good faith commercial agricultural use of the land. Now, it sounds like you're just repeating yourself, but then they go into considerations, but it's up to him to make those considerations. Addressing what Jim was saying about the gap period, because if you don't have an operation that satisfies being in existence and complying with these restrictions, what do you have? Well, what we said in the minutes the last time, and I think I was the one that suggested this, is that we have a cleanup bond and an agreement that would relate, in this case, to the agricultural purpose of the land. And we let them know beforehand, as part of the agreement, that we will monitor their activities on an annual basis, perhaps in some way that it tolls the ability of the town to say, you have changed your operation to become a nuisance. And you can be controlled as a nuisance and told to cease. And if you cease, we have a cleanup bond to clean up the property, and they go on and sell it or do something else with it that is in compliance with our code. So I think that, you know, the earlier discussion we had about the affidavit that they make, well, putting teeth behind it is to have a cleanup bond. And if they're trying to get more rights under agriculture than they would have otherwise, we have wording in there where they've agreed, in a sense, to remain in that challenge category under Florida Right to Farm, where they can become a nuisance. And if they remain in that category and they don't pursue a bona fide agricultural purpose, you know, then we tell them, you've got to cease and desist. And if they say, you know, they're not going to do it, they go before the magistrate, they get a fine, they get a lien, and if necessary, you know, they lose their equity in the property. You know, most people with any sense wouldn't do that, but to protect ourselves, we've got a cleanup bond that they put up that says, okay, if you're going to clear the property and it's going to cost $50,000 to replace the native vegetation that you destroyed, you know, that's part of what the bond would be used for. Or if you created a real trash heap there with whatever you tried to do that wasn't really ag, because you never got it to be an agricultural use, that
Are you
bond is there to
suggesting
clean it up.
anybody that comes in with an agricultural use needs to have this bond? I think that's unreasonable.
No, I think that if during this gap period, if they're trying to do something unusual or questionable, I mean, certainly if they came in and said, we want to build a 20-stall barn for, you know, commercial equestrian, you know, we say fine, you know. But if they say, you know, we want to grind glass and use restaurant waste to, you know, develop worms, and they wind up with a complete imbalance of things where they're not producing as many worms as they're creating noxious odors and really creating a nuisance, we've got them under control where, you know, we say, you know, you came out here with a questionable agricultural use and, you know, you haven't lived up to fulfilling that use. And it was non-standard use and you created a mess. And so now you clean it up.
All right, let's, Howard?
Everything you've just said before John got off in his direction is doable by ordinance. Okay? A town ordinance can go ahead and take care of that transitional period that you're talking about. Okay? The letter of intent that John referenced is no different than the letter of intent that the Palm Beach County Tax Appraiser's Office and Business Plan used to accept, and according to your recent information, the new regime has decided not to accept that. That, by the way, is also being challenged, okay, because somebody in Royal Palm Beach ran into problems trying to put up a fence for his livestock because some inspector said you can't do it until you're already ag. Okay, and all of a sudden Butts has taken a 360-degree turnaround on what he told you. All right, so the whole point is there is no issue that you have brought up yet that says we should keep agriculture in the ULDC. That transitional period can be regulated by ordinance. I agree with what John said up until he started to interchange the word nuisance with whether or not you're bona fide ag. And let's not get hung up in the
Minutia.
minutia, because bona fide just means exactly what John said it means. It means good faith. That's why it's not specifically defined in the Florida statutes. Just means good faith. Good faith commercial activity. So, again, it doesn't belong in the ULDC. It belongs in all kinds of ordinances for things you're bringing up. As a planner, you know what pitfalls are out there, but the way to handle them are through ordinances, not through the ULDC.
Mark? I'm just curious what Mark would have to say.
I mean,
Jim?
what's really the difference between an ordinance that's adopted and incorporating that ordinance into the ULDC?
Because the ULDC is not supposed to be regulating agriculture. It's for development, and agriculture is not development. Now, just because it's been done in the past and every county that you can think of has previously done it, doesn't mean that we should continue to go in lockstep with all of that. We're an agricultural community. We're supposed to be thinking outside the box, independently of what's being done in Wellington or Royal Palm.
All right, let me ask a question then to Jim, when you made a good point. So, to you, Mark and Jim and Braden, you have an ordinance versus having a ULDC. What does that mean to you? What is the limitation of having it in an ordinance?
It would have the same effect.
Well, okay, so it would have the same effect. So, there's stuff, I'm just seeing the other side of Jim's argument when we started this conversation to wrap this up here. Jim came forward to us and said, there's some things, let's review them, there's some ag issues in here, let's review them. We're talking about doing an ordinance. There's things that already existed here that, my question is, do you want to have one more discussion where you bring us that summary? Is that what you're suggesting? And let's wrap this up and get it over?
Well, that's what I was proposing.
Right, that's what
Was
my,
was that we have, we have all of these different opinions on what the definition of ag is, bona fide ag is, what this statute says, what that statute says. I'm saying, let's put it all together in one package so we all have it in front of us to look at.
so
And then
when,
if we want to pick and choose, as to which of those sections we reference in our code, ordinance or ULDC, whatever, we have those documents right in front of us, so we know exactly what we're incorporating.
okay, so what you're saying is, we come back one more time and we have this discussion with you,
Yes.
with a summary in front of us, and at that time, we can look at what you're saying
Yes.
versus having an ordinance.
Yeah.
Just so we'll have something to compare, like,
Yeah, I
okay, if we had an ordinance versus having this summary,
Yeah, even if we use this thing as a handbook of references.
that's not necessarily in the ULDC.
That we have available to use when the issue of ag comes up. I mean, I think it's a good tool for us to have.
Sure.
Yeah.
Comment though, on, because we go back to the gap thing. Can they be agriculture without without the land being bona fide?
Without land being greenbelted.
Whatever you want to call it, I don't care. We're talking about the property appraiser giving it this wonderful name that everybody treasures. Can they not perform agricultural
Sure, I could.
jobs or build an agricultural barn without the property being zoned in Palm Beach County as ag and having the ag benefits, et cetera?
Yeah, I would say that they probably can, if you look just at the definition of agriculture. Now,
Because like, for example, if somebody just lives there at their house and they have a 2-stall barn with 2 horses, the barn and the horses are ag, but the county might still not put that property as bona fide ag.
yeah, that's right.
So then there really isn't a gap, because it depends on what they're doing. Does the gap really matter? That's really my question, because that's what you brought up.
Yeah, well, I mean, if the gap doesn't matter, then let's make sure that there's nothing in our code that implies that there is a gap.
Okay,
Now, there's another way I think that we can address this. Now, we've had the issue of the vermiculture and the grinding up of the bottles and creating the soil amendment. We were struggling with, okay, when does that become agriculture or bona fide agriculture? We sent a letter to the Agricultural Extension Service. And we got an opinion back from them that said that, yes, this is bona fide.
Which is what Beckett said.
So maybe there's a way that we can incorporate that into our codes, is rather than waiting for the property appraiser or staff, uneducated staff trying to make it.
And that was, I think, the suggestion from Beck to last meeting or previous.
That's another expert recognized source, and she seems to be very willing to give us an opinion every time this issue comes up. Is this bona fide ag or not? And she's answered yes or no every time we've asked her. So that's a potential consideration. I mean, is the town willing to go along with her interpretation?
Okay. Zara, make it short because I'd like to.
I think that, as we said the last time also, that the key would be balance. They'd have to balance the waste and the amount of glass they were grinding up to harvesting or breeding or whatever they do with the permaculture. And we'd have an agreement with them that they would maintain that balance and they would preserve the nuisance challenge to the extent that they let that get out of hand.
Yeah, that's right, and that gets back to my point of the gap period. That scenario gives us the opportunity to impose some conditions that all of the neighbors that live around that property would be very pleased that we incorporated prior to that project being built.
All right, Howard?
Okay, again, we come to bona fide ag, good faith. You always have the right to question whether or not it's a good faith operation. And as I earlier suggested, you could go to the tax appraiser's office and ask them to investigate if someone has a green belt, if they should continue to have it. You as a town, I don't know why you couldn't write an ordinance that you could make sure it was bona fide ag. Now, again, bona fide ag, good faith, commercial, agricultural activity. So the town basically would have the right to say something is no longer bona fide ag if they're grinding 50 tons of glass for every 20 pounds of worms they come out of it.
Balance.
Okay, let me
And
ask.
that's what John said about balance.
One more quick question. Would the definition of good faith include making sure that the operation did not, for example, create an odor problem with its neighbors?
You have any of the neighbors have a year to complain.
Yeah, but what I'm saying is we would have the opportunity then to take the definition of good faith and say, okay, here's some potential issues that might come up. This is how we'd like you to address them.
Well, you could always say you're not a bona fide agricultural pursuit, yes.
Okay, let me suggest this because it's 20 to 8 here, and we've kind of been talking about this in circles here. Did you want to make another public comment or not? You said you did you? Yes, no? Because I'm really trying to wrap this up here.
Well, I was going to suggest that if maybe another solution could be that the town comes with a definition of agriculture that includes everything on the Florida statute, but adds certain things that are agriculture that are not on the Florida statutes, like the aviculture. So the town could have, their own agriculture definition, but better.
All right,
We're going against Florida statutes.
All right, let me ask this. You made a motion. Okay, we started with a motion, and this has been going on for over 30 minutes, and we haven't really gotten anywhere. What would everybody, Jim has offered to come back with something. Do you want to hear it or not? We're now down to ordinance versus ULDC.
I don't think it would hurt to get some.
One more go around here and.
And
have
that's
Jim-
at least what Jim is saying. He said, look, let me throw some ideas on a piece of paper. You guys can look at them, read them, and then we can say yes, no, or whatever.
Okay, so we can table your motion to the next meeting, actually give Jim the opportunity to present his information, and bring that as, do we call that old business then? Or is that going to be new business, Mark?
And it can't take any longer than 5 minutes.
Yes. Let's keep
I think
it,
anything related to agriculture has got to
just
be open.
line items, let's line items, because we keep going around, you know, we're beating the same dead horse here, okay?
I know, that's why I'm trying to get you an input.
All right.
Now, we're also going to bring up the AGO question.
No.
So they have to be tabled to next week, next month.
Okay, we'll table the AGO question for the next meeting also, but we can't even get to that question until we resolve the agricultural. So I'd like to ask that we table Howard's motion and that we allow Jim to do what he's been trying desperately to do for months now and bring those things forward and.
But we whittled it down significantly,
Yeah,
at least.
yes, absolutely.
Can I make a closing observation?
Yes, please.
Okay, 'cause one thing Howard is correct, the statute says good faith, but if you looked up the definition of bona fide means real or genuine. And I believe that's how the state of Florida then means good faith. That's really what they want to see in agriculture. I've been dealing with agricultural issues, God, since like 1998. And I'm a believer in agriculture. I think, you know, it's about saving farmlands and all the things that we do. And I've also seen an evolution. And what has happened is you have a lot of pseudo-agriculture out there, because Florida was a state that was ripe for this. People wanted to jump in and make sure their interests were protected under ag, just like developers do when they throw 3 cows on a property so they don't have to pay taxes. That's where all the issues come in, with the pseudo stuff. I mean, I could even use the aviary. I think there was that one opinion by the county or somebody that said, oh, well, you're just raising pet birds, therefore how is that ag? Well, you know, depending which way you argue, I'm a dog lover. If you're going to use that argument, then kennels aren't considered ag, but yet, you know, if you're raising dogs, they're useful to humans. I mean, the problem is in the code, the section that really threw everything out of kilter was that statement about useful to humans. Once they put that in, that gives almost everybody and their brother to argue that something is ag, when you really need to get to the basics of what is ag. That's why I think you have good, you have the bona fide term all these things came into play, which really made the whole thing really a confusing issue.
Okay.
That's why you get into the interpretations, that's why you get into all the regulation, otherwise it would be an easy thing.
And that's going to be for P and Z and Town Council, but next meeting, which is going to be when?
19th, I think? 19th, I think it is.
August 5th, okay.
19th.
I'm not seeing it. It's on the agenda? It says August 15th.
It says August 15th.
Okay,
It's
so
August 19th.
September 19th?
I mean, September 19th, geez.
Okay, that's okay, I appreciate it. All right, so we can try and come up with some type of advisory opinion.
5:30 again, right?
I think we settled on that time.
Okay.
Okay, closing comments?
Yeah, I got one. I'm extremely disappointed in our forward movement. I think the very first meeting that we had, John and I were on the same page. We had this handout, Article 75, non-conforming uses, and he said, let's go through any notes we have made, and I figured, wonderful, let's do that. We didn't get into 30 seconds of his presentation that we got sidelined by something else completely different, and we've never come back to that.
Would you like to bring that to the next agenda?
Bring it up then.
Okay, I'll bring it to the next
Article
agenda. You
75.
read yours as well, because you never got a chance to read your notes on that.
Was that the historical legacy?
No,
No.
no, this is non-conforming uses, structures, and plots, Article 75. We were given that from the get-go, and we were told to go through it and ask any questions we had about the wording, what needed to go, what needed to be changed. And I know John spent time doing it because he wanted to start out the meeting.
You're saying we kind of ran through it and didn't do it.
We ran through it, we never came back to
We were supposed to come
it.
back to it, other things have come
Madam
back.
Chair, if we can do this, all of you send me any emails relative to anything you think we didn't go over in full force, or anything else that you think either that wiped away or whatever, and what we'll do is we'll take all that, so, I mean, we may not be able to do it all in the next meeting.
Yeah, we're gonna start with Jim's
Yeah,
issues.
And we'll schedule it out.
Okay. Katie?
I agree with Howard, that we need to go back and on that stuff.
Okay. John?
You know,
Wait, we're
plodding forward.
we're still breathing, okay. I did want to mention something that happened at the town council meeting. Mr. Harris came forward and made a public comment and accused the ULCC committee, not accused, but I think he misspoke in the way he presented it to the town council. He basically said that we had not made any decision on commercial equestrian, and I distinctly, again, I don't review the tapes that I distinctly remember Beck made a motion that commercial equestrian be a permitted use, and we all agreed 5-0, I thought, and I stated that. I jeopardized myself once again before the town council, once stated that we had made a decision, it was a past decision, so therefore no violation of sunshine law.
Right.
And then he did say he was upset because it had not, 2 P&Z meetings have been canceled since we made that, so.
He, if I can,
Yes.
you're absolutely correct. In fact, you may remember I turned to you and I said that wasn't a fair statement, but
That's
I
why.
didn't get a chance to, basically, I think his concern was there have been some folks that have gotten up there and have gotten what he believes are quick relief from council, that he's been raising this issue and it's been dragging on, and I think the chair did a wonderful job of getting up and at least trying to contest that. We've had several conversations. I think, I am a little shocked because our office has been working with him to try to assist him in the matter. And I did make the comment to town council that was, we went before them and asked them for the authority to move the special exceptions ahead of everything else. Because we're not really amending anything right now. We're taking your input and providing it into a summary for council for future action. However, Jim has provided me with a draft that we're going to be moving forward in September to the P&Z board. One of his concerns was the P&Z board meets and operates based upon if we have applications or not. If we have no applications, there's no reason to have a meeting. We made a strategy change in how we were going to handle the CIE, and that was one of the reasons why we moved it quicker through a different mechanism. We didn't need to have the meeting, and that was the point. It wasn't that we were canceling P&Z meetings so we wouldn't address this issue, and it wasn't that you all didn't address the issue, because you did. So I think he's just emotional about it, he wants to make sure.
Mention the option also that apparently the lady, there's some lady got up there who was having an issue in her pool, she went before the town, and it involves a text amendment. I don't think she understood the term when they said you do this at your own risk. All she cared about was getting her building permit. But they did say to him, and this I want you to be aware of this too, that he could go before them individually at the town council meeting and ask for ask for what is it called? They said come, Ron Jarrell was very clear, he said come before the town council.
Yeah, what he tried to do is he tried to change it to a zoning in progress.
And is
And
that?
I said we don't need that because we are working on it.
Okay.
What the zoning in progress does is it allows you to maintain your use because you lay out a scenario of what the regulations that you're working on are going to do. Bottom line is he can do what he's doing right now under the county for another 6 months. And I expect that we're going to have that special exception process adopted. So he won't have a problem. But again, he's emotional because he's concerned. We understand that. But again, I think he said it very poorly, but it made it sound like this board didn't really try to help him. And then the P&Z board was not acting on it, because he is a P&Z board member, so he.
Well, we were not trying to help him individually, we were trying to help the community.
That's correct.
And he just happens to benefit from
That's
what
right.
we were doing. And you had one, go ahead. Don't entertain it, what the heck tonight? Go ahead.
Real quick, I don't want to volunteer you five for more work than you have to do, but since the Planning and Zoning Board doesn't meet every month, would it be possible for you guys to meet an extra time once a month in lieu of the Planning and Zoning? It wouldn't cost the town any extra time
We
because they
can't
have the
approve the
time.
planning and, give the planning and zoning approval.
No, but what I'm saying is they're not having a meeting. So that means that relieved them of the work for that meeting. So why can't they invest that time into an additional meeting for you guys to have a meeting here?
Well, here's the thing, let me address that. That's a good point, Todd, that's been talked about.
That is good.
When we first created this, we said if, by September, it looks like we still have a lot to do, and
We
we
do.
would double up on the meetings. We would have 2 of them.
Okay.
To try to finish within the sunset provision.
Because I mean, like
Had
this
to
agriculture
remind
thing, this agriculture thing gets
Is
pushed
it-
off every month.
But
Is it all possible to change the order?
Wasn't it real clear that we would come up with an initial recommendation, but it had to go through planning and zoning
Right.
because of their
You
jurisdiction?
would come up with your recommendations, we would go back to council, we gave them like, almost like a mid-year report, and that was just to give them an idea of what we were doing. We would come back with a full report, all your recommendations as to what happens, and then it's up to council to either throw it to the P and Z or.
I thought when we established the order at the beginning, that we would deal with some recommendations and they would be forwarded to planning and zoning because of their jurisdiction.
No, I never understood it that way. I would never do that to P and Z without going to town
Okay.
council and
All right.
get their
I thought
stamp of
I thought
approval on
town
it.
council wanted our recommendations to get concurred in by planning and zoning and then go to the town council.
What you're referring to, I know what you're referring to, part of that discussion when Cirillo and myself, we were all talking about that issue, was that ultimately, you couldn't be you're almost like a charter review committee in a way. Think of you as like that. You could make recommendations about charter changes, but you're not the ones doing it. In the case of land use regulations, everything still has to run through the P and Z board.
Right.
But what council wants to do from a policy standpoint, first they make the call, and then they would direct us to go P and Z or whatever. the case
So,
may be.
so that plays
Like
into what I wanted to
ordinance-
say.
Ordinance versus ULDC.
That plays into what I wanted to say. Well, wouldn't it be, since we're seeing how this works out in the real world, and it doesn't seem to be working, okay? Can't we reverse it? Can't we have it go before the town council first? And they approve it, and then it needs to be underwritten by planning and zoning? But then it would already have town council approval, and we could eliminate that step? That's number one. Number two, Jim Rocket was explicitly clear that he didn't want to receive a, I forget what he said, 200, 400-page document and have to go through it all at once. He wanted this stuff fed to him little by little as we go along so he could digest it in his normal time period. And what you just said seems to believe they're going to get it all at once, and they didn't want it all at once. They wanted it piecemeal. So something as small as the Harris issue, okay, could go to the town council, get approval, and then before it goes into effect, planning and zoning has to sign off on it. That might make everybody feel a lot better
It's a
about the
violation
forward
of the
movement.
statutes though, Howard. Florida statutes require that if you're going to do land development regulations, it has to go through
First.
PZ first, you know.
Never mind.
I don't
Yeah,
want to
that's the only,
slight,
that kills that, that's the only reason why.
I don't think we should slight P and Z. I mean,
No, I agree.
you know, to have our recommendation get approved by the town council and then given to planning and zoning saying, well, we don't want your input, we don't want you to review
Oh,
it.
absolutely no, they're too much experience. We're
Right.
fortunate to have the people on that P and Z board that we do.
And you know, that's,
I always thought that made it logical. We would give kind of a community input as a recommendation. It would go to planning and zoning and they'd refine it, however planning and zoning experienced people refine it, and then it goes to the town
you
council.
know, like when I gave them the mid-year report, you know, it was maybe a month short of the mid-year report, you know, I asked them, I gave them the option, I said, do you want me to go through every definition, for example? I said, because we spent a lot of time going over definitions. They didn't want to hear this, they just wanted a rough idea. So I know what you're saying, you know, Councilman Rocket said, but I think at some point it's going to end up being, I'll probably give them one more report, and that's why I'm asking them to identify any last issues that if they have a problem in the ULDC that they haven't told us about yet, so you can address them. And it's probably going to be, it's not going to be cleaned up over one or two meetings. When we bring back the full report of what you've done, yeah, we're going to have to probably chop it up and do it over the course of several meetings and have them give the direction how they want to handle it.
And what we need to do is go through our notes, and like Mark said, if there's something, just like you said, non-conforming, we need to put that back on. Go through your notes, if you see something you want discussed, email Mark, he'll forward it to Jim, but next meeting, Jim's first on the agenda, finally, meeting adjourned. Be nice to us, Jim. Sue? Yes.